Hey, AP Gov guys, Walls, we're here. Stuff is starting to trickle in on how the exam's going to work, and I will get that stuff to you instantaneously once I have like a really clear-cut understanding of how it's going to go down. Obviously, you're going to be taking it from your houses, and they have a system in place that will prevent cheating. So anyway, keep getting your assignments in, man. They're just assignments that deal with exactly what's going to be on the test. Because this is an AP course, I do have a pretty good idea what they're going to ask you on the test. So, when I give you a set of like 14, 15 court cases to take a look at, those are important court cases. Those are court cases that show up, and I'm gonna have a few of those. I'm gonna talk about today too. Anyway, just to review what we've been doing with the Supreme Court. Okay, so Article 3 of the Constitution establishes our Supreme Court, and the system of, I guess, inferior courts, they're called, smaller courts that hear cases that may or may not one day get to the Supreme Court. The jurisdiction is the authority of the federal courts. Remember that jurisdiction may be the original jurisdiction. It could be the appellate appeals jurisdiction or concurrent jurisdiction, meaning that it is shared by both the federal and the state level courts. You have a Supreme Court, the Court of Appeals, and district courts. Remember, there's 94 district courts, and these are all your constitutional courts. Supreme Court, Court of Appeals, and district courts are all your Supreme Court constitutional courts. Supreme Court, as I've mentioned before, is created in Article 3. It's created by the Constitution of the United States. It is a fundamental part of the United States checks and balance system, and was originally kind of outlined by Baron de Montesquieu, if you go back and take a look at that. Supreme Court is the highest court in the land, and the Supreme Court is what determines whether a law that was created by the other two divisions, legislative and executive, is constitutional. Federal judges are appointed by the president and are confirmed by the majority in the Senate. Remember that. So you saw this, the most recent example of this was Chief Justice Kavanaugh, and you were more than old enough, I think you were a junior or a sophomore, for his appointment in the Senate. And he was appointed despite the fact that there were some allegations of sexual harassment and or rape against him. But they were deemed by the senators to be without, the burden of proof was not upheld. All your federal judges are lawyers, are great lawyers that have been serving in, or very qualified lawyers, you would assume, that have been serving in the political forum for a very long time. Keep in mind that Supreme Court only hears a few hundred cases a year, and there are thousands of cases submitted to the Supreme Court on a yearly basis. That's important, but that's why they have these. They have district courts, and then they have courts in which, or they have precedent in which they will say, hey, look, man, we've already ruled close enough to this to where you have precedent, and so we're not going to hear the case. You can, present a case via a certificate, the writ of a certiorari, yeah, or an amicus curiae brief. This is how you can present to the Supreme Court. So you give them this certificate, or you give them a brief. Oral arguments are then allowed after the briefs. Law clerks research most of the stuff that's going to be presented in these particular arguments. And then the key here is that your Supreme Court decisions are going to be explained in written statements that are going to be the opinions of the various members of the court. Okay? And there's the majority opinion, which is, hey, look, 5 of us believe that this is the way it should work, and this is the majority opinion. There's the concurring opinion, which is sort of the ends justifies the means opinion. So you didn't really like how the decision was made as a justice, but you're going to support the decision because you think the decision is correct, but not really the way the sausage is made is bothering you. Okay, and then of course there's the dissenting opinions. Right? And with dissenting opinions, these are individuals who are like, no, justices that are like, no, this is not, I don't believe that this is constitutional, or I believe this is constitutional. That's a dissenting opinion. Okay. And this gets us, just to review, this brings us to the idea of political parties in the Supreme Court system. So, we're all human beings. We have different perspectives on things, and those perspectives can typically in America, we have and I'm going to talk about this quite a bit with political parties. We have liberal and we have conservative, and then we have the center. A vast majority of the people are sort of in the center, but there's you guys know how this works. You've seen this forever. And the issue comes up in the Supreme Court if, for example, let's say, hold on a second, I'm trying to give you a case. I'm looking for a case. Hold on, kids. I'm looking for, let's use something like Schenck v. U.S. Okay, 1918 or 20. I really hold on a second. Let me see if I can find Schenck v. It's like 1920. It's I think we're gonna go with 1920. It's right after Schenck v. U.S. was a freedom of speech case. And it was a guy was distributing anti-draft and anti-war propaganda during wartime, and I believe it was Oliver Wendell Holmes that said that during war, the freedom of speech can be infringed upon by the federal government. So there is an example of a more conservative take by a Chief Justice on an issue of freedom of speech, because I don't think anybody would say that limiting freedom of speech during wartime would be a liberal thing. Okay, so that's a reasonable example. It's not the best example. But it's solid. Remember that, the foundation of our country is this notion, or one of the primary foundations of this country is this notion of habeas corpus, where You get an opportunity to present your perspective to a court and to have a jury of your peers. Okay, now, certainly Lincoln suspended habeas corpus in an effort to keep Maryland a free state. There were a lot of secessionists that were, well, not a free state, to keep, strike that. Maryland was not a free state. It actually stayed a slave state, but a Union state is what I meant to convey to you. So Lincoln will suspend habeas corpus during the secession period because he needs to keep Maryland, where the District of Columbia is, he needs to keep Maryland in the Union. So that's a straight up suspending of habeas corpus. Is that constitutional? He did it. It's the same thing with like the Alien and Sedition Acts back in, that was under John Adams, I believe. And John Adams he suspended, like Alien and Sedition, he started rounding up Frenchmen and French dissenters who wanted us to side with the French in their troubles with England. So we have these things that are really unconstitutional, things like Alien and Sedition, and things like Lincoln's suspension of habeas corpus. But all of this all of these cases that we've been looking at are all predicated on that right of habeas corpus. You have a right to have your perspective heard by a court of law. That is, a fundamental part of our Bill of Rights. Let me think about some of the other cases I gave you. Let's take a look at, Engel versus Vitale, 1962, in which prayer is deemed unconstitutional in public schools. Okay, so if we have a situation in which individuals are trying to pray during the school day in public school, and that is seen as a separation of a violation of the separation in church and state, which is part of the Establishment Clause. And the Establishment Clause, many of the cases you looked at had dealt with either the Establishment Clause and the Free Exercise Clause. Now remember that the protection of religion, right, is free exercise. The separation of church and state is the Establishment Clause. So remember, Congress shall make no law respecting the establishment of a religion or prohibiting the free speech. That's as basic as it gets. So a lot of the cases that I gave you kind of dealt with that Establishment Clause and Free Exercise Clause, which I want you to really understand. Engel versus Vitale is a big one. Lemon versus Kurtzman in 1971. This one's very interesting because we're at a Catholic school, and this is where a very important term called the Lemon Law comes from. And what the Lemon Law states is that you can be reimbursed as a parochial school, a Catholic school, for textbooks and to some extent teacher salaries using state or federal monies. So religious schools can get money from the state or from the federal government. However, it must pass a Lemon test, and that is that the stuff being reimbursed, as I understand it, and I am not an attorney, I only play one on YouTube. As I understand it, is the stuff that the federal government or the state government is reimbursing you for, this Lemon test, it can't be Catholic stuff or Jewish stuff. It has to be stuff like mathematics books. Maybe you want to apply for a grant from the state for computers to use for creating new algorithms that would pass the Lemon Law, okay? As I understand it. So there's Lemon versus Kurtzman, and that's a good example of the Establishment Clause, that the state government should not be giving money to establish parochial schools. But there are going to be examples where the fact that the school is Catholic has nothing to do with it. And we saw some of this in Douglas County a few years ago. Douglas County was considering giving vouchers to parents who opted to send their kids to private schools. And this brought up the question of the Establishment Clause, because if they're giving that voucher to the parents, is that establishing private parochial schools? And I believe Douglas County, and I might be wrong here, ruled that they could give vouchers. I don't know. I don't think they ever did. Then we have things like the free exercise law, where we see things like Wisconsin v. Yoder was one of the cases I meant to give you, which was Amish kids in 1972 it's ruled that they don't have to go to public school because they're beyond 8th grade, because it infringes upon their belief set. So these are the types of things that you're going to see in a lot of cases. You also had Texas versus Johnson, which is the famous flag burning Freedom of Speech Act in 89. I remember that case, actually. Dude was burning flags. And they ruled that, look, man, symbolic speech is free speech. So I hope that, another term that I kind of want to just really quickly touch on and make sure, by the way, when I do these videos, I'm assuming that you will pause them and write down something that's really important. Remember some of these things that are really important. Ex post facto laws, laws that are applied to acts committed before the law's passage, are unconstitutional. So if you committed something that wasn't a crime but is then later deemed a crime, they can't go back and get you with it. This is similar to things like remember that you have the Fifth Amendment, which protects you from self-incrimination. There's also the notion of double jeopardy, where you can't be brought up on the same charge a second time. Let's look at like the O.J. Simpson trial. O.J. Simpson cannot be convicted of Nicole Brown Simpson's murder in 1994 because he has already been tried criminally for the murder. Now, he was tried in a civil court, and a civil court is typically a financially punitive court in which he lost. It's a wrongful death of Nicole Brown Simpson, and actually he lost to the Goldman family. So he lost in civil court, but he won the case in the criminal court. Those are, that's food for thought. So take a look at some of the cases I gave you, and let's see, refer to your book for the Supreme Court information, and I will keep coming back at you and chiming in. Now, I am going to be, I have figured out Zoom. I did my first AP Euro Zoom today, so I'm looking forward to trying to get an AP Gov Zoom. Now, the purpose of those Zoom things is really just for us to get together, and if you have some questions, ask some questions. So I will try and get you an invite, and I don't know how many of them I'm going to be. I mean, I got one done today for AP Euro, and I'd like to get you guys done one day this week. So look for an invite in your box. Keep up the good work. Love you, and be safe.